OK. How obedient. Bonjour tout le monde. Mon nom c'est Barbara Nice.
Hello, everyone. My name is Barbara Nice. I'm from Newfoundland.
Panel. And the focus of the panel is, do we need corporate criminal liability, perspectives of business and labor? So how the panel is going to work is I have a series of questions that I'm going to pose to the panelists. And after they have discussed those questions, we will open the floor to the wider audience. And the first question, and they each have 2 minutes to respond to this tiny little question: what is the significance of the Westray bill? I'll introduce the panel, but each of the panelists will tell you just a little bit about themselves. So we have on the panel Jamie Jerzak, who's here. Next to her, we have Kenneth, is it you?
Joel.
Joel. Kenneth Joel. And Steve Hunt. Oh, no, that's not Steve Hunt. Céline Giguère. And then Steve Hunt. So, okay, Jamie, you're up.
Thank you. Just a little bit of my background in terms of the perspective that I'll be speaking from this morning is I am a management side, primarily labor and employment lawyer over in Winnipeg, Manitoba. And I do a lot of defense of prosecutions for companies that are charged under the Occupational or Workplace Safety and Health Act is what it's called in Manitoba, but under the OHS legislation. Our jurisdiction hasn't had a criminal negligence prosecution as of yet, but I've certainly obviously seen them happen across Canada. The other things that I do in my practice, which I think also gives me a unique perspective, is I'm also on the ground doing legislative compliance training, but as well I do grievance arbitration from a management side perspective, primarily dealing with situations where employees may be terminated and safety is the alleged for a safety violation and discipline. So I'm seeing it from a management perspective, trying to work within not only trying to address their corporate compliance, but in that sense trying to enforce some of the safety rules they put in place. Another bit about my background, which I think is worth knowing, is I also own a small business. So I'm also a small business owner who's dealing with some of these things from the perspective of an employer. Having to look at this and deal with employees, deal with compliance, not just from the legal aspects of being a lawyer and helping my clients work through it, but also as a manager sitting there going, oh, I guess I'm a senior officer. What does that mean for me and my business? So I just wanted to let you know that as well. To answer the question that's been posed to us from that perspective in terms of what is the significance of the Westray bill, speaking from that management perspective and what I've seen, I guess, my clients go through over the course of time that this piece of legislation has been in place, is the initial reaction I saw in terms of the significance was it got attention. I saw my clients react in a way that they hadn't reacted to anything. They got, for lack of a better term, they got scared. And they were pulling me and other people like me in to do training to try and ensure that senior level management, mid-level management, supervisors, employees understood that there had been a significant shift and that there was a heightened risk, not that there wasn't a risk before, but a heightened risk of real penalties, of significant penalties if people weren't paying attention to safety and health in the workplace and ensuring that injuries were prevented. Then nothing happened. And I found that employers went, well, then what's the fuss? What was the big deal? And the focus then shifted back to just looking at the regulatory legislation, the provincial legislation or Canada Labour Code, Part 2 prosecutions under the OHS provisions of the federal legislation. And on some levels, I think my clients and in truth, myself and my other OHS counterparts across Canada in terms of the defense bar looked at this and went, well, that should be okay because they're still focusing on due diligence. And everybody's reading at that point of a very much untested piece of legislation was, well, if we can prove due diligence from an OHS, from a regulatory perspective, we're probably not going to get to that wanton and reckless disregard standard because, well, if we're duly diligent, how were we disregarding safety and health? And the decisions that came out of Quebec in 2010 seemed to sort of reinforce that when this legislation started getting some courtroom time and some written decisions. But more recently, the Metron construction decision that was released this summer, I think has given some people pause to go, well, wait a minute, is being able to prove due diligence under the provincial or the regulatory legislation enough? Because in Metron, it looked like it was one site supervisor's almost rogue behavior, smoking marijuana or being high or potentially high on site, that led to the prosecution of a company. And we had a site supervisor that was treated what many would say was mid-level management, and people thought, well, this is not a senior officer. The court said, oh, no, this person is a senior officer. And so now what I'm seeing is a shift again back to my clients going, we got to pay attention to this again. And we have the potential for real risk and real jail time. However, I'm still seeing that dichotomy of clients who are going, but we still see a higher risk of fine and penalty coming from the provincial or the regulatory legislation than we do from Metron. And I've seen a few examples of that recently where the fines that are coming out of certain jurisdictions still tend to be higher than what we're seeing under the provisions of the criminal code. So when we talk about the significance, I still think some of my clients are struggling with seeing that when the penalties that they face under the regulatory legislation are still more significant in their eyes.
Thank you. Monsieur Yord?
Hi, my name is Ken Joel. I'm an adjunct professor at the University of Toronto. I teach a course called Financial Crimes and Corporate Compliance. I'm a co-author of a book called Regulatory and Corporate Liability. And to Steve Biddle's point, the rest of the title is From Due Diligence to Risk Management. So I'm one of those guys that talks about risk management. I practice as well at not a small business, but at a firm called Baker McKenzie, which is the biggest law firm in the world. We have 72 offices in about 45 countries, and we're a global firm. I want to talk to you today about my thesis of Bill C-45, which is that I think it has yet to date unfulfilled promise, but that I think the legislation has great promise, but it hasn't been fulfilled yet. And I say that for two reasons. One, the power under this legislation to put a corporation on probation. And secondly, the drilling down, as was just said, in the concept of senior officer to the operational side of the business beyond simply the making of policy. I think that's a very fundamental change. But I want to tell you a story that illustrates why I think this bill has so much potential. Many, many years ago, when I was not at Baker McKenzie, I represented a company. It was just starting as a very young lawyer, and I represented a company that was charged with occupational health and safety offenses with not putting up guardrails when they were building a building. And a worker fell and was very, very badly hurt. The Crown Attorney wanted a $100,000 fine, which back then was a lot of money. And I came up with this, what I thought at the time was a brilliant idea. And that was, I said to the guy, why don't we hire an expert in safety? That expert will go out and train the workers. That expert will file a report saying that that's been done. That expert will monitor for the next 6 months to a year your safety on the premises. I think I can get the fine down to $10,000. We'll spend $50,000 on this guy. You'll still save $40,000. On top of that, you'll have a safer workplace, and you'll be better off because you can then go to the worker safety. As you know, you have to pay fees for workers' compensation. You can go to them and say, look, we've really changed our practice and we've solved this problem. My client said, no, I don't want to do that. I'd rather pay the fine. And I said, I don't think you heard what I just said. I said, I can get this fine down to, I think, $10,000, right? Reduce the fine. You spend $50 on the report. That leaves $40,000. You pay me. You've got a few dollars left. I mean, it's a good thing to do. This is a smart thing to do. And he said to me, no, I don't think you understand. Now, let me explain something to you. I'm not putting guardrails up in the future. I'm not. Okay? It takes time. It slows the project down. It goes to what was said in an earlier presentation about the business case. I'm not doing it. Pay the $100,000, and I can pay it today. I have a check. That's what happened. Paid the $100,000. I went home. I took a shower. You know, I felt like this is just a disgusting process to me, that this had happened. And what came out of that was a concept that I wrote about in the book, and so I want to circle back to the idea of corporate probation. We suggested in our book the concept of an embedded auditor. And this is how it would work in that situation. Instead of paying a $100,000 fine to the government, which goes into some amorphous fund that you may or may not see again, this would be the concept. You put the company on probation. You say, the $100,000 that you were going to pay as a fine, you're going to pay to employ that safety expert. And that safety expert's going to report back to me, the judge, 6 months from now, and then a year. And that safety expert, when I say embedded, they're going to be at your premises from 9 to 5, Monday to Friday, day in, day out for the next year. Now, if you do that, not only will it specifically deter companies, but it will generally deter companies because other companies will say, we don't want these guys looking over our shoulders. We better clean up our act to make sure that doesn't happen. So I think, has it been done yet? No. I think it can be done. And in the United States, and I'll just close on this, there's tremendous, this is done all the time and under a different scheme called the corporate monitors. And what they do in the United States, and firms like myself, our firm negotiates these all of the time. We will go to the regulator and we'll say, we'll put in a corporate monitor. It's often in areas of financial crime, like foreign corrupt practices or price fixing. We will put in a corporate monitor from one of the forensic firms, PwC, Kroll, whoever. And they will report to you, the government, in the next 2 years. All we want in return is what's called a deferred prosecution agreement or a non-prosecutorial agreement. We'll pay a fine, but we don't want to be prosecuted. We don't want to make an admission. So we get something. You get something because you've got a monitor on the field, in the field, ensuring in the next 2 years that there's compliance. And I just want to end on one other thing that reflects on my thinking of that little company. I think one of the things that I've noticed in representing at Baker McKenzie, we represent large companies. And what's interesting about that is they care actually a lot about their reputation because they spend a lot of money, a huge amount of money in marketing. Whereas the smaller companies, the fly-by-night companies, don't care. They can fold up their company. I see Harry Glassbeck here, who taught me when I was in my graduate work, and he makes a great point in his book that these little companies, they can just roll over and recreate themselves as a new number company, and who cares and who knows? But the big companies that have invested massive amounts of money into their marketing, they can't do it, they don't want to do it, and they will spend a lot of money trying to comply. Not only for reasons that it's good for their workers, but because it will affect their market reputation. And they spend a lot of time, and on that level and on that point, I think Naomi Klein, when she wrote the book No Logo, was wrong. Because in some cases, the marketing of these big companies actually has a silver lining, and that to me is the silver lining. So that's my initial view of C45.
Merci. Madame Giguère. You need a microphone.
My name is Céline Giguère. I'm counselor for the union at the SCFP. I'm also a lawyer, and I practice in health and security for 20 years now, and also president of the committee of the FDQ, Federation of Workers of the province of Quebec. And when I was asked to come here today, my first reflection was following C21 in our workplace in health and safety was to think of a quote. I don't know the author. I thought it was Catherine Lepel, but I'll start by this quote where one says, you can poison your spouse by dropping a bit of cyanide in his coffee. After 5 years, he's going to die, and you'll be accused of murder. You can expose a worker to any other toxic product every day. After 5 years, he's going to die, and we'll say that he died from a work-related death. So this is the basis of the conundrum. The problem of C21 is the conforming. We've normalized this concept. So I think it's normal that our first reaction is not to criminalize. Our first reaction is not to call on to C21 in an automatic way. And it is in this context, in normalization of the risk, that it is difficult to draw the line between a just death and an unjust death or an unfair death with the introduction of C21. It's this normalization that is one of the obstacles, hindrance to C21, and it's also our own behavior. It's not our first reaction. And I think we've spoken about this, we've touched on this earlier, but this economical situation, and even for unions, the loss of jobs that it can entail, these are things that people have in their conscience before they actually lodge a complaint. So it is true that it had some consequences first of all, the employers, especially the large ones, first of all, they attempted to exonerate themselves. They made training with lower level management or with workers, explain to them what was due diligence, and to explain to them that the onus was on them of safety and health in the workplace. So we had to explain to the workers that who were afraid of after the adoption of C21 that they were going to be held responsible and to be accused. Thanks to this law, we had to explain to them that if they did their job according to the methods accepted, that there was no risk to them, that the organization of work was not their thing, that the methods it wasn't them that decided of the methods nor the tools that they used. So we had to union-wise, with a certain work, to reassure the workers that with the C21 and what the employees wanted, really, what they were attempting, they were giving us their sacrosanct right to exercise their management by brandishing C21. So we thought that it could have had in Quebec, the fines that are associated to the infractions, they are not very costly for the employers. And we thought that that could solve the problem in a certain way if we could act on these fines. For instance, for the same type of infraction, I won't go into details, but what could cost in Quebec $3,000 to an employer, the same infraction in Ontario could cost $60,000, just to give you a scale. So we thought that the introduction of C21, the employers would facing the fines that they could be stuck with, that they would have activities of prevention and of improvement of health and safety. So this does not turn out the way we expected. And if we look, there's the cause, the company that was fined $100,000 following the death of a worker, associated with $100,000 fine, nothing else. And we did not use this. The other recommendations use this, put this company on probation to exercise surveillance on them. We didn't use these tools that were available to us by the modifications to the criminal code to follow up on that company. There was a fine of $100,000 that was paid. That's end of story. There are other causes that are pending. A dealership, car dealership, where the worker was following a device that wasn't working properly, and we encouraged people to keep on working with it. He was seriously burned. He wasn't able to continue his job. There are important consequences for him and the company itself, in virtue of the infractions, saw a fine of $15,000 handed out to them. So the service manager was accused of criminal negligence, and the sentence came out, and he got an absolute discharge because he was a good citizen. So you see this disconnect. This is not the results that we had hoped for. Another impact, according to me, that we haven't seen the consequences yet and that could have consequences, is that we use the occasion to include the unions and the workers. This notion that we included, we didn't see what this could come out as, because there hasn't been any cases that have come forth. But in the future, we could use this to that the unions could be, because there was no contract in place. Steve Hunt.
Thank you. Good morning. Let me first thank the organizers of the conference for the opportunity to speak. I've been fighting for the West Ray bill since it was passed, well, long before it was passed, the lobbying. So my name is Steve Hunt. I'm the Western Canadian Director for the United Steelworkers. That means I'm responsible for the 4 Western provinces and the 3 territories. And unfortunately, in District 3, which is Western Canada, we have the worst fatality record in all the steelworkers in both Canada and the United States. We kill more people every year than any other jurisdiction. So unfortunately, I've come to live with workplace deaths and come to fight with them. I started as a miner in 1973, came on staff with the steelworkers in 1984. And have been involved in safety since my career started. I was a health and safety chairperson in 2 mines that I worked at, and have a pretty clear understanding of this. So let me take you quickly to West Ray. I know we're hitting time. So you know what happened at West Ray on May 9th, 1992. The mine exploded and killed 26 people instantly. I thought, because we're talking about West Ray and the importance of West Ray, it'd be important that some people have alluded to Justice Richards today. Let me also back up. Let me thank Andy King for getting us this far, and my colleague with the Steelworkers, and Rob Champagne, who's in our National Legal Department, who's also given us a huge lift on trying to move the goalposts to get closer to prosecution. And I'll talk a bit about that as well. I thought it would be appropriate just to read this as an opening. Again, I know we're pressed for time. This is from Justice Richards. It usually goes unnoticed and unread. The West Ray story is a complex mosaic of omissions, actions, omissions, mistakes, incompetence, apathy, cynicism, stupidity, and neglect. It's a story of incompetence, mismanagement, bureaucratic bungling, of deceit, of ruthlessness, of cover-up, of apathy, of expediency, and of cynical indifference. It's a tragic story with the inevitable moments of pathos and heroism. The West Ray story concerns an event that in all good common sense ought not to have occurred. It did occur. And that's our unfortunate legacy. Let's flash forward 20 years ago. That's when Westray happened. May 9th this year, I attended the Westray Memorial. Very solemn, sad event. And Alan Martin, who leads the family group at Westray, said this to me, quote, "I can't help thinking that the reality of corporate greed, lack of political will and oversight, bad managers, and a continuing lack of justice are still with us today, 20 years later." So when you think about the impact that had on many, many people. Now, I testified at Westray. I was called an expert witness. I was asked to testify on why workers do what they do when they know it's unsafe. Everybody that worked at Westray apparently knew it was pretty unsafe. So I was asked to testify on behalf of the steelworkers at that hearing. So I have, I guess in some respects, I think a rightful position to talk about Westray with passion. I followed the mine inspector, Albert White, sorry, was his name. White went underground a week before Westray exploded and wrote several orders. Mitigate the gas, mitigate the dust. And when he was asked on the witness stand just prior to me testifying why he didn't go back under to enforce the orders, his comment was, "I didn't want to go back underground. I knew the mine was going to explode." So if you talk about negligence all the way down the line, including the regulators' negligence in Westray, it's real. So at any rate, Westray, we promised, I just got to back up. So after 20 years, nobody's gone to jail. But we made a promise as the steelworkers. We fought this campaign for a long time. As you know, we were the lead, as other speakers have talked about today. We pushed it. We lobbied, 2 lobbies on Parliament Hill to get politicians to pay attention. They did. And if you read Hansard today, if you go back and read why the Westray bill was there, it was as a deterrent. It was supposed to be a signal to employers. Don't kill people. And if you're negligent, you will go to jail. That's what they all said, including people like Stephen Harper and others. So the recommendations that we said, no more Westrays, ensuring proper criminal investigations take place in all serious injuries and fatalities, ensuring that the police, workers' compensation boards or administrators of labor, and prosecutors work together and adequately trained. Sorry, that's the question, so I'm going to go to the first question, I'm sorry. Questions of the panel. What's the significance of the Westray bill? Again, we were the driving force. On the books, this is what the Westray bill says. The possibility of criminal charges makes a difference. But the deterrent effect of the reality of more charges being laid and some of the actual prosecutions of convictions is still missing. So that's what the employer side says. You know, you can practice due diligence, and that's what's going on. So we're proposing to make Westray work in 4 ways. Ensuring proper criminal investigations take place in all serious workplace injuries and fatalities. Making sure that police, workers' compensation boards, Ministry of Labour, and prosecutors work together and are properly trained to do the investigations in a way that can successfully take on Westray prosecutions. Let me stop right there. If a police attend a motor vehicle accident, the first thing they look at is, was there a criminal act? Alcohol, drugs, speed, maintenance. That's what they look at. They're trained to do that. If they're called to a suspicious death, they immediately go into the criminal mode. They're looking to see, why is that death suspicious? Was there a murder? Was it a suicide? They're trained to look through that lens. When they're called to a workplace death, they wait for the regulators to show up. And then they discharge the scene, usually to the coroner, and they're gone. And that's basically the extent of what police are trained to do. Prosecutors, in my experience with prosecutors, and I talked to a number of prosecutors when they will talk to me, one of them said to me, and I'll remember this vividly, we'd rather prosecute an impaired driving charge because we'll know we'll get a conviction. We're familiar with the law, and these workplace laws we know nothing about, and we don't want to jump into that pool and be the first one in. So, it's kind of pretty basic, some of this stuff. 3, establishing a dedicated prosecutor in each jurisdiction like Manitoba has, with the workplace and legal knowledge to bring charges and successful prosecutions against guilty employers. That's something that we can't do. Prosecutors, and I'll talk to you a little bit in a subsequent question about a case that we took on where the prosecution just simply just sucked. They were bad, really, really gutless and bad. If necessary, lobbying for changes to the criminal code so that prosecutors and convictions can take place. That's the first question. I'm going to just add a comment. I'm not worried about a company going bankrupt because they kill somebody. If they kill somebody and one of the consequences is they go bankrupt, so be it. There's no other part of our society where you can kill with impunity other than in a workplace. If you're XL Foods and you poison people, there's a consequence. You lose your company. You lose your right to manage. And maybe you'll go to jail. If you're Maple Leaf, maybe you'll go to jail. If you make a product and you do something that's defective, you can be sued outside of the workplace and you can go to jail. But in the workplace, once again, you can kill with impunity. And there's all these fallacies. Well, you know, companies go bankrupt every day for a myriad of reasons. If you can't manage the company safely, there's no due diligence defense in this one. It's a death of a worker, and if you were negligent, then there should be consequences. Those consequences are at least clearly spelled out in the Criminal Code of Canada. And as Alan Martin said, the problem with this is there's no political will right now to enforce. That's the problem.
Okay.
Thank you.
Thank you, Steve. Okay, so we've used up much more than 2 minutes per person, but I think we've covered off some of the other questions that I was going to pose to the panel. So I think what I'm going to do is actually go to the, because I want to leave time for the audience to participate in this discussion. So let's go to question number 4. Okay. If you have notes. So we're looking for question number 4. And we're back with Madame Jerzac. And the question is, what factors impede this legislation from being enforced more often?
From my perspective, I think we've heard some of this answer already. We heard with Professor Toombs this morning was the issue that our law enforcement officers, RCMP and police, are left in a situation where sometimes they don't have the resources or the training to deal with the workplace investigations. Mr. Hunt mentioned this as well, the idea that the officer arrives on the scene and releases the scene to the regulator immediately. So I think that's very much just the practical reality. And I mean, having dealt with law enforcement individuals over the course of my legal career, just in terms of the labor and employment side of things that I do, the constant comment I often have from our local Winnipeg police is just the lack of resources to deal with, again, this idea of the real crime or the true crime, let alone now they're going to have to start dealing with the workplace issues. And then they're looking and going, well, we've got a team of, regulatory investigators that can handle this, I don't want to say for us, but there's the resources that allow us to go and deal with the crime that we're seeing on the streets. And I think we also deal with, we've got the political will, but we've also got a public perception. If I'm talking to, somebody on the street who's going, well, as an individual, I'm worried about safety on my streets. Depending on where they sit in terms of their day-to-day lives, are they necessarily concerned about a workplace fatality? And I'm not saying that's every person. There's going to be people who are definitely concerned about that because they go into it every day, or they've got family members that go into it every day, and I can speak to that as well. I mean, in the sense that I do know people that go to work every day, and I go, gee, I hope they're going to come home. But depending on where you sit publicly, you're sitting there going, the police should be enforcing the true crime, and we've got regulators to do that. And so I think that's part of it, too. When we're talking about political will, we've also got the politicians that are focusing on those issues of making sure the true crimes are getting the attention. So in terms of just a general comment about what impedes the enforcement, I think it's that limited resources and where the political will is directing certain things to go.
Thank you. Mr. Jones.
I think one of the problems is education. C-45 is a complex piece of legislation. It is not easy to interpreted. My law students struggle with it. So I think part of the thing that we need to do is keep educating. I'm trying to do that in the law school class that I teach. I don't think we should underestimate the RCMP, and I join my friend and my colleague with respect to the concept of a specialized prosecutor. I think that's an excellent idea. Don't underestimate the RCMP. They have, for example, in the context of white-collar crime, formed the IMEC groups, and they're working very aggressively with specialization. They bring in lawyers who are part of the team, forensic accountants who are part of the team, in addition to police officers who are dedicated to this. In another area, in the area that I spent some time doing, in the area of foreign corrupt practices, the RCMP have 2 dedicated teams that are very powerful and very good at what they're doing. They just can't talk a lot about what they're doing because so much of it is privileged and of course it's in the form of investigations until the charges are announced. But believe me, they're out there and they're working very hard. And I don't see any reason why there couldn't be a further development of those models. So I think those are important things. Let me give you a couple of suggestions that I think might help enforcement, because that seems to be a recurring theme. If you look at other regimes, one is the Competition Bureau enforcement of price fixing. They use, and the United States Antitrust Division of the DOJ use, a concept called immunity and leniency. And it is very powerful. And how that works is it applies in the cartel cases where you have companies getting together to fix prices. The immunity program says this: if you're the first company in, you get immunity, and we won't prosecute your directors. If you're the second company in, you get leniency up to 50% off, and we won't prosecute your directors. If you're the third company in, you only get up to 30%, and we don't give you any guarantee about not prosecuting your directors. And what happens in these cases where you've got 8 or 9 companies who are engaging in collusion and price fixing is they start getting nervous, and they start thinking maybe somebody's going in, and it creates a domino effect. It's a rush to get in first. So that's one thing that people should think about in the context of workplace health and safety. And it's never been tried, but it's something that works. I can tell you it works extremely effectively. Second thing is whistleblowing. In the United States, the Dodd-Frank Act, and although it may seem kind of crass to us as Canadians, they pay whistleblowers. They pay whistleblowers. If as a result of a whistleblowing, there is a conviction that nets over a fine of over $1 million, the whistleblowers get a percentage of that, and it can amount to millions of dollars. And they get effective prosecution. And they put people in jail because there's an incentive for people to come forward and give information. I mean, if you're really serious, that is a way to enhance people coming forward. Third thing is compensation models. In North America, we don't tend to compensate people for compliance. We compensate people for performance. We compensate people with stock options. We compensate people with bonuses for performance. If they do well, they get bonuses. If they stop a deal, if they're compliant and they say, look, this is an unsafe workplace, let's stop this. Let's stop it right now. They don't get compensated for that. Our model doesn't work that way. We should change that. We should change that. We should compensate people. We should give them bonuses for stopping an unsafe workplace. That doesn't happen in North America. We should change that.
Okay, thank you. Madame Giguère.
Just to tell you a little anecdote. In December 2007, there's a port worker in Three Rivers who had his right leg cut off, lower than the knee, and the other leg was fractured in several places. Following this accident, I participated to a complaint to the SQ Provincial Police in December 2007. Twice, we were asked complements of information, and to last news, and once in a while we call, where's our complaint, at what stages is that? It is now on the desk of the prosecutor. The worker had several surgeries on the leg that was left, readapted with a prosthesis, and went back to work on the dock, and we still don't have any news from the prosecutor. I think it speaks for itself. The training of the police officers, of the prosecutors, I think there's a lack. These are delays that are simply unacceptable after 5 years I won't go into details, but this is quite straightforward. It wasn't too complex in the documents that we forwarded, either to reject it or have it followed through. So I think this is one of the problems. There's also this absence of training that's prevalent. The police officers, when they show up on the scene of an accident, they will check to see if it could be a murder, or if it doesn't look at anything, they just go away. And then they're called out and say, wait a minute, you guys should go further. There might be criminal negligence. Well, this is not under our work description. Even the regulators should take care of this. Even the police officers don't have the proper training in this matter. And there's also our own behavior. I think we can say that indeed these are all impediments, hindrances to the application of the law, but to the enforcement, we don't make enough noise. I think we should. We don't do it for several reasons, but we'll have to move beyond these reasons and to put first and foremost the health and safety, what my colleague was saying earlier. I think that our objective in health and safety is to eliminate the dangers at the source and to continue our work to denounce the employers who do not make any prevention in place, who jeopardize the health of the workers, justified only, but we all need to work. This is very lame. We take the workers in hostage. We force them to work, and even large employers. The conditions that they put their workers under duress, under threat, because we all have to earn a living. So as far as I'm concerned, these are all hindrances. These are all impediments. And I agree with all the other reasons that were enumerated, but we have to look at our own behavior and to make sure that the laws are enforced and use them for their intent.
I want to preface question 4. The problem with panels is you never have time. I could speak for an hour on this, but I know we don't have time. But let me talk about Lyle Hewer. Lyle Hewer was a worker in New Westminster, British Columbia, worked at a sawmill and died one day. I won't tell you about the gory details. Sufficient to say, the regulator investigated, so criminal charges should be laid. There was willful and wanton disregard for the worker's safety, those words, willful and wanton disregard for the worker's safety, and assessed the biggest penalty assessment in British Columbia history for that workplace death. The New Westminster Police Department investigated, and uncharacteristically, a sergeant who had not been trained in workplace investigations or accidents or fatalities, recommended the criminal charges be laid as well. It went to Crown once. Crown rejected without reasons. It went to Crown twice. Second time, they rejected without reasons. And the third time, we took on a private prosecution, the steelworkers did. And we brought it in front of a judge, called evidence, established in the eyes of the judge there was enough to proceed with a criminal prosecution. And for the third time, Crown stayed the charges. And that brought the case to an end. So when I speak once again with emotion about this, I'm angry. Hewer died where he shouldn't have died. Hewer should not have died had they been taking the steps that they should have been taking to ensure that they didn't extend wanton and willful disregard. We should also say that the day the fatality occurred, the company had a sudden computer problem where all their computer files were erased, including the minutes of the safety meetings. Unfortunately for them, we kept them. We had them in paper. So there was another criminal act at that point, we say, that wasn't pursued by Crown. In that, there was a letter to the board of directors. And the board of directors received a letter saying the safety committee recommended a change to the device where Hewer died. And the response to that in writing was it would cost $30,000. And they just said no to the changes. Should know that after Hewer died, they spent the $30,000 to fix the machine. So in that case, if there was a willful wanton disregard and this one didn't ring every bell that people at Westray, people that drafted the Westray bill thought, I missed it. So what are we thinking of doing? We're considering, as we talked about earlier, and I think most of the panel agree, a dedicated prosecutor like they've done in Manitoba, like we'll likely get when the government changes in British Columbia. Also a dedicated police officer that could be assigned to look to workplace deaths. In the alternative, we're also looking to change Section 21711 and 2171-1. And we think we can make a subtle change to make it clearer and a slightly lesser standard, more akin to the civil negligence as dangerous driving under Section 249, or the careless use of a firearm under Section 86(1) of the Criminal Code. And this is the opinion that our legal counsel gave us on this, quote, certain kinds of activity involve control of technology, cars, explosives, firearms, with the inherent potential to do such serious damage to life and limb that the law is justified in paying special attention to the individuals in control. Failing to act in a way which indicates respect for the inherent potential for harm of those technologies is legitimately regarded as criminal. And we think the same logic should be applied in the test when a worker dies. And I'm going to qualify this. I think people know that I am emotional about this type of stuff, but I'm not suggesting every employer go to jail. I'm suggesting where employers are negligent and it can be proved that criminal action should take place at that time. So again, once the police release the scene after they're trained and they determine that there is no criminal activity, then the regulator comes in and does the investigation at that point, not the other way around. Currently, the regulator investigates and the police come in after the scene is disturbed, after evidence is moved or erased in the case of Weyerhaeuser. And I think a simple approach, once again, look at it through a criminal lens and amend the law if necessary. So the steelworkers are prepared to go back to Parliament Hill and continue to lobby. We'll look for other people to come with us to ensure that we make the changes necessary to the Criminal Code of Canada so that workplace death is not something that is just part of doing business.
Okay, thanks, Steve. The floor is open, and I'm probably going to, if there's enough interest, we'll gobble up a few minutes of your lunch. Yes.
Laura Lozansky. I'm the Occupational Health and Safety Staff Officer at Canadian Association of University Teachers. I just had a comment and then a question. I'm really concerned about some of the comments that are coming out saying that, people don't have enough training, and I'm talking about prosecutors or employers. They don't understand Bill C-45. It's too complex. It's been well over 10 years. I was a factory worker, and then I was a nurse for 30 years. I saw workers get injured, and then I nursed them for 30 years, watching what came through the door, some pretty horrendous industrial accidents. That, to go back to some of the comments made from an earlier speaker, this is, if it's all about common sense, should never have happened. It's been 10 years. As a nurse, when every year, in order to hold my license, I had to show that I was doing continuing education. I had to keep up with the changes and know what was going on, or I couldn't hold my license. I had to show that every year. I don't know how it works with law enforcement or prosecutors, but maybe that's something that should take place, because there's no reason after 10 years that people can still continue to say that we don't understand it and we don't know. And if you're going to be an employer in this city or this province or this country, it is your responsibility to know what the law requires of you when you hire workers in your workplace. And not say, well, I didn't know, I didn't have the capacity. There's lots of places out there to get the assistance. So I guess my question is, I heard the comments particularly from the first two speakers around either lack of expertise or proposals for how they could help employers fix things in the workplace. And one of which I have to say with all due respect, I'm a little appalled at the notion that good employers should somehow be compensated for doing something that's morally expected and legally required of them, i.e. Provide a healthy and safe workplace. So I haven't heard anybody address workers, unions, or joint health and safety committee members. I shouldn't say anybody, but I'm talking about particularly the first two speakers. You know, where do you see them fitting in? They have the expertise. They don't have all the expertise, obviously, but they bring the expertise. They bring it from the workers who know the workplace. They have the training, and in fact, what ends up happening is unions end up with much of the expertise because we're forced to. We're always forced to do the things better in the workplace and more for our workers in order to keep our members safe. So I haven't heard anything from the first two speakers on where you see the role of workers, unions, or joint health and safety committees in this process.
Yeah, I definitely would like to comment on that. I think it's going to be one of those situations that the classic lawyer answer, well, it depends. In defending employers and working with employers to reach their legislative compliance training, I can definitely tell you that the employers that get it, that understand what their obligations are, that understand how the Westray Bill works, that have paid attention to what's going on. First of all, they see, if you want to talk about compensation, their view is that they just won't get charged, and that's good enough for them. And I mean, that's probably a good thing all around, but they're also coming at it from the perspective of, you know, we're doing this because it's going to send employees home safe, not because they're afraid of what the legislation is. So I think you have to look at the mindset of the corporation. But those employers that tend to be viewing it from that perspective tend to have fully functioning joint health and safety committees, tend to have serious involvement from their employees, and if it's a unionized workplace, the unions. And so, I mean, having not commented on it, I don't think it means at all that, from my perspective, that I don't see that as a huge part of it. In fact, it's very significant. And I think the comments about the lacking expertise, I don't know that it's necessarily a suggestion that people can't learn it if the opportunity is given to them. I think that certainly, again, the workplaces where I've gone in to do the training or I've seen that they've had the training, they get it. I think it's just more an issue of whether the training has happened. I'm not saying it's an excuse, but I'm just saying that I don't think anybody's suggesting that, I come from the jurisdiction that has the dedicated prosecutor. So, I mean, I can tell you that, when people take the time to give people the expertise, I think they can learn it. It's a question of whether the will is there to make sure that happens. But I do think that workers, unions, joint health and safety committees can play an integral part of making sure this works. The flip side, because I see this too, is I see the workplaces that, of course, they don't care. They're the ones that may get prosecuted or, there but for the grace of God, they've had a near miss and they haven't yet, and they still aren't reacting to it. And those are the workplaces that may not have taken the time to get the training done or to work with their employees or their joint health and safety committees to make these things happen. Those are sometimes also workplaces, and I mean, I'm going to probably get skewered for saying this, but not all unions, unfortunately, are created like the steelworkers where they're advocating, and I've sometimes dealt with situations where the employer is actually fighting with the union because, and I'm dealing with one workplace right now where every single time the employer tries to work to enforce a safety rule that they're seeing an issue, it's grieved. And their enforcement efforts are getting stymied, and they're sitting there going, how are we supposed to ever make the workers take this seriously? And this is a situation where it's a very specific workplace where they've got a lot of due diligence in place, and the enforcement seems to be stopgap. And I'm not suggesting all unions are like this. It's one example that I can speak to where there's been a huge issue where the employer is trying desperately to get the employee buy-in. But I've seen workplaces that have unbelievable relationships with unions or in non-unionized work environments with the employers where they've got this beautiful symbiotic relationship, realizing that you got to work together to make this stuff happen. So I don't think any of the comments today, I mean, were meant to suggest that the employees or unions or joint safety and health committees can't be trained and given the expertise to make this happen. I've seen it done. And that it isn't happening. I think our comments today have really been focused, though, on, it's always our case where we see the worst of the worst, right?
Okay. Thanks. No, I'm not, no, because I wanted to get more questions on the floor. And if you could be brief in presenting your questions, that would also be useful. Okay, yes, please.
Hi, Sergeant Eric Martin with the RCMP's International Anti-Corruption Unit. I've heard a few references thrown up there about law enforcement's presence and perhaps, and I wouldn't argue it, perhaps a lack of expertise, training. So sort of a two-parter, but I'll keep it brief. Part A is, I guess myself representing the International Anti-Corruption Unit, and I'm actually also affiliated with the IMET unit, I'd welcome any sort of feedback from anyone up there in terms of what kind of training you might see as beneficial for us to have. Sometimes I guess we portray ourselves as knowing a little bit about everything, but really at the end of the day we're not necessarily experts in all areas of law enforcement. But consider part B to this when you're answering the question. Having had some considerable experience dealing with some larger corporations in a slightly different venue, when we're talking IMET and anti-corruption, it's a little bit of a different angle and focus, but you'll see where I'm going here. When we walk through the doors and I wave my hand and I say, hi, I'm Eric Martin, I'm with the RCMP, let's have a chat, I hear a lot of crickets. So at the end of the day, and I'm not talking about suspects, I'm talking about witnesses, I'm talking about the people that we need to speak to in order to do our job. Steve, I'm looking at you at the end of the panel for this part. I mean, we talk about lobbying and whatnot. Any thought given to, you know, and I'm just throwing this out there as a topic of conversation, but the compellability of witnesses and that sort of thing, because at the end of the day, one of the reasons that regulatory agencies are relied upon by law enforcement is because regulatory agencies have the ability to compel, and law enforcement doesn't. And at the end of the day, we can talk about training in units, just throwing it out there, but if I don't get any information and any evidence, I'm bound by what the criminal code authorizes me and my unit to be able to enforce. And if we don't have the evidence, we can't enforce it. Not defending anything, like I said, I really do welcome the idea of training because I don't know, I'd love to pass that along. And Mr. Joel's comment about the formation of an IMET / International Anti-Corruption Unit model, I'd love to hear more about that because, again, I'll pass that along willingly and gladly. Thank you.
Okay.
All right, good question. You know, coincidentally, I was at the Workers' Compensation Board the day before yesterday in British Columbia asking for funding so we could train police officers and Crown Counsels, and there was an affirmative response to that. And one of the things we talked about is building a team. So it'd be RCMP or civic police, municipal police that would team up to start the investigation, and again, look at it through the lens before it's released to the investigators, to the regulators, sorry, and the regulators would work hand in hand with the police force to investigate, to ensure, right out, as I keep on saying, look at it with the criminal lens first. And if the police are satisfied that the regulator is generally satisfied that the workplace death was not occasioned by negligence, then the scene is released at that point. If the regulator says, look, we should look at this through a criminal lens, at that point there's reciprocal agreements in every jurisdiction, or almost every jurisdiction, where the police take over and the right to remain silent is assured at that point. But only after the decision is made at the front end of the investigation to proceed to criminal charges, or at least look at criminal charges and investigate I guess, bad word, but opportunity to proceed to criminal charge. And if that's satisfied, then we do it. And I also want to comment for your colleagues. In no way are we angry with the police forces. No, but it's important that we say that. It's not anger, it's frustration that we can't get justice, we can't see justice served in this case. There's a case that's been sitting on an RCMP sergeant's desk now since 2008 in a fatality in British Columbia. It's been sent to Crown and sent back, sent to Crown, sent back. And we know what it is, justice delayed. You know, that's all they're doing is running the clock. And hopefully people will forget. And we hear that from the RCMP. They're frustrated as well.
Okay, Mr. Joe.
I've had the pleasure of working with Sergeant Martin, so I know about his expertise. What I'm suggesting is, for example, in the IMET team, you have forensic accountants at your disposal. Why not have, in the context of occupational health and safety, engineers, for example, who can give you technical advice about the engineering on a particular site and whether or not there's compliance? That's the kind of thing I'm thinking about. The other thing I just want to make a comment about is John Braithwaite in Australia has developed a theory of restorative justice, and he talks about talking to the regulator. And I'm a huge believer in that. And I talk to the regulator all the time, sometimes on a no-names basis. And I have a good relationship with the regulator. And that allows me, on behalf of my clients, to help compliance by having discussions which work towards compliance with the involvement of the regulator. So we try not to have the crickets when you come in the door, but it involves a frank relationship to be able to do that.
Okay, we've got time for one more question.
Andrea Peart with the CLC. I just had a comment and a question. The comment I just wanted to make was in reference to this morning's speaker about the cultural shift. And I just wanted to point out, because personally, and I know we're all here as individuals, it's something that drives me absolutely crazy, is that when Céline mentioned, if a woman gives her husband a teaspoon of poison every day, 5 years he drops dead, she doesn't. At no point did anyone feel the need to say, most people don't try to kill their husbands, it's just in cases. But when we talk about occupational health and safety fatalities, we always have to premise it with this, as though we aren't anti-employer, as we aren't, and in no other facet of life or criminal justice do we feel the need to give this backstory. And I find it quite interesting because it sort of reflects some of the cultural barriers that we face. But that being said, I just wanted to ask a specific question, which is less in the case of a fatality, but Kenneth Chell mentioned this concept of an embedded auditor, and I was curious to have the perspective of the other panelists, in particular Céline and Steve, to hear how you think something like that, if it would function, again, not so much in the case of a fatality, but in other cases.
I don't know if you could ask the question in French again. Okay, I wasn't quite sure with the... Listen, I talked about this before with the employer was convicted of a $100,000 fine, and nothing happened after that. It's very easy for certain companies just to pay out. The probation orders with auditing and all that, I think that is allowed, and it's desirable. I don't know how it's going to be done, of course. We could discuss that for a long time, but yes, I do think it should be associated with probation orders and specific recommendations that could be verified following the conviction.
In some jurisdictions, it's not auditors, but they put companies on the bad companies list, and they warrant more oversight than others. It's not really well followed. Once they're on the bad list, they just get more inspections than they normally would. But there's no follow-up. But let me put it into context for you. For not a workplace death, you have an employer that exposes a 20-year-old worker to asbestos in a demolition project. How do you audit that after the employer goes out of business? That worker's going to die, maybe, likely, and the worker knowingly exposed that person to asbestos. For what? Profit? Yes. No due diligence. So how do you audit once the employer is just going to pop up somewhere else as another employer with a different employer number, and that's the problem with chasing these criminals down.
Okay, I'd like to please join me in thanking our panel.